2025. So those who have not attended earlier webinar, for them, Happy New Year to all of you. Friends, as you are aware that on 20th December, we concluded our 200th webinar, and we have called the galaxy of speakers across the regulatory body, parliamentarian, regulators, ministries, professionals, and various industry people. This journey of knowledge sharing is a part and parcel of corporate professional now. Every Friday, 4 p.m. to 6 p.m., we have created a brand, and on this, we organize program without any fail. Our program we are doing, even if any problem is there, until unless there is a holiday, national holiday or big holiday on that particular day. So friends, this journey is going on, and today we are welcoming all of you for 203rd webinar. And today's topic is also very, very important. This is succession planning through trust. As you are aware that every business succession planning is very crucial. And that's why in the governance also, succession planning, which is a responsibility of the corporate and the promoters of the company, the government wants that it should be part and parcel of your corporate governance norms. And that's why everybody is talking about the succession planning should be there. If a company has no succession planning, then it will face problem. No doubt, first succession planning issue came when we are talking about the employee point of view, that what is succession planning if this employee leaves. But simultaneously, this issue comes with the management also, the promoter also, if they are controlling the company, how they are managing. As you are aware that earlier two brothers were there, now their brother's son has come, son has come, and the business is growing. Now, the interesting point of Indian business is very, very important, which we have to understand. In the family-owned business contribute more than 75% of Indian national GDP, which is one of the highest percentage globally. This share is projected to rise 80 to 85% up to 2047. This is the prediction. Worldwide, what is happening, 60 to 70% in developed country and developing country, the family-owned business, but India has a 75%. And the interesting point in this, that out of this 75% of total GDP, the 75% business, they don't have any specific succession planning in place. And that's why we can see that India ranks third globally for 111 family-owned companies having a combined market capitalization of $839 billion. And same way, the 2017 to 2020, the family-owned business, India reported approximately 2.3% higher revenue as compared to non-family-owned business, because skin in the game and you are doing this. And simultaneously, shareholder return is also 24% compared to 18% for non-family-owned business. So you can understand if something is shareholders are getting more and they are contributing more and they are giving more return, then this business continuity is not a bad. And when we are seeing the 80-85% will grow, it's very surprising figure, which is a data that in place of going to professionalism, professional companies, the family-owned business will increase. But there is a one catch here. The catch is that earlier family-owned mean the family-owned business, they manage business their own style. But now the family-owned business is managed by professional way and professional style. So that's why professional management practices are improving, governance is also improving, operational efficiency is also improving through professional, and they are adopting very competitive means also. Now, it is not that the succession planning is far from the challenges. There are so many challenges also, mindset challenge, the governance challenge, adopted to a modern practice, because family-owned business started their own style and they run with their own process. So to change this is also a difficult task. Before going to the detail, I just want to tell everyone that today we will discuss various aspects of this concept, where why succession planning through trust, type of trust for succession planning, benefit using trust for succession planning, challenges in succession planning through trust, because nothing is free from challenge. Sometimes lack of clarity in trustee, lack of family dispute or regulatory issues are there. That is also point. Tax and regulatory implication of trust creation, best practices for succession planning through trust. All these points today we will discuss, and that's why the today's our learned speaker is Manoj Kumar, partner head in M&A of Transaction Corporate Professional, and then we have a Ravi Prakash, associate partner, Security Law and Corporate and Litigation Corporate Professional. And Ruchika is not well, so she will possibly may not able to join, but Manoj and Ravi will do the needful for today's presentation, and they will cover the how the trust, why the trust, what are the trust formation, how trust is formed, what are the issue, what are the challenges, and then Manoj will discuss about the nitty-gritty of trust, and then he will discuss about the listed companies trust, because that is also very important, and tax aspects of trust, which is one of the most favorable things that people are following. Now, friends, this issue comes in everybody's mind, that why I want trust and what is happening. So I'll just giving you some few example that these people were not having a trust formation of succession planning, or their succession planning was not there in place. So by saying succession planning is not a succession planning, you have to have a complete set. I'm just giving some example which has destroyed the business of Indian corporate family. One popular case is Ambani family. There's a dispute between Mukesh Ambani and Reliance, and we have seen this, that one group like Anil Ambani, after this dispute, they have destroyed the business, and today the companies are bankrupt. Okay. Suppose they could have a trust, then they could have done something great. Then Bajaj family dispute, that is Shikhar Bajaj and the Rahul Bajaj dispute, which has taken place. No doubt, Bajaj Group, the Rahul Bajaj Group is doing very good, but the sometime when you have a fight, so your business may grow, but your image is dent. You will get a dent like this. Then come to the Modi Group, which is one of the previously earlier we can say Tata, Modi, and Birla. These are the three main segment, and Modi Group dispute is well known. And in this, and that was a very bitter. And the all the brothers initially they have lost business. Several business, Modi, Rubber, Xerox declined too, and they have disappeared. The group has lost its stature, which has a complete business. Ruia family, ISA SR group, we have seen that Shashi Ruia, Ravi Ruia, SR, they have a dispute, and because of this, they got mounting liabilities on the debts, and they were not able to pay, and that's why the various company has gone to insolvency also. Now, these are some example of Indian. If you say international example, we have seen Samsung Group. The dispute after the death of Lee Kyu Nee, Samsung chairman, a feud broke out among his heirs over inheritance. No doubt, the group is doing good, but they got a dent, and they got a liability of 10 billion inheritance tax also. Same happened in the Gucci family, Italy. And because of this, the family dispute led to financial loss and mismanagement, and family eventually lost control. And today, the French luxury group, Kering, with no family involvement, is managing. So Gucci family is out, but Gucci brand has run by Kering. This is a French brand. Then come to the Hayat group. That is, they were managed by Pretty Zar family, and family unity were destroyed. Businesses continue, but they have lost control over this. So this is one issue that business either destroy or you lose control or your control is drastically reduced. Same thing happened to Murdoch family, Fox News in USA. They also have done this. So what are the example which I have given? What we have learned? We have learned simple, clear succession planning was not there. Unified vision was not there. Because I told you that two brothers are managing, then their sons has come, and then sons has come. So new generation thinks on differently, and you think on differently. That is a point of dispute. Then external influence, sometimes it's also taking a toll on this. That is a main point. Now, issue in family business without trust system, which we are discussing today. First is ownership dispute hota. Second, leadership conflict start because everybody manages differently, and two brothers thinks differently, and their sons also thinks differently. We are settling various family dispute. We have seen this. Asset mismanagement is there because there's no clear guideline, and then tax inefficiency is there, and one brother is managing one business, second is managing another business, but second business is larger where other person has a stake, but the person who is managing bigger thing, he say why I should share because I have developed this. So these things create a dispute. Tax inefficiency is there, family dispute takes place, lack of continuity. That is a disadvantage of this trust system, is in absence of trust system. Now the question is trust system can create all these problems away from? Yes, answer is it can reduce drastically. One is defined asset allocation. Second is and how this trust could have ensured fair and transparent distribution assets among the family member. Example, Ambani family could have avoided splitting their empire by establishing clear ownership terms through trust in the beginning. So the Reliance brand could have been same and the people are managing separate. Then leadership clarity is there. Who is the leader? Who will manage? That is also another part. Mahabharat we have seen. It was a leadership issue that Duryodhan will manage or Yudhishthira will manage. That is the leadership clarity was not there. Conflict resolution mechanism is there. Because Modi Group family that has that dispute has taken place, and because of they were not able to manage their internal dispute. That's why long-term planning is missing. If the trust system is there, they could have planned this. Protection from debt and mismanagement, because one person is managing a different way and there is no uniformity in the process. It is happening. And so if trust is there, then you can take. And the why people choose trust over trust for succession planning, because they want to preserve as wealth, avoiding family dispute, control over distribution, continuity in the business, and confidentiality is maintained. And practical side is if trust is there, it's a flexible in design, avoidance of probate, asset protection is there because sometimes lawsuit and tax and creditors cannot touch that. Efficiency, asset management, dispute mitigation, continuity during incapacity. Sometimes somebody is not able to manage or some problem is there and the successor is not able to control things, then professional management can do. Tax side is also, which Manoj will explain, the tax efficiency is there. And other advantage is that you have a charitable intention that can be done. Cross-border asset management can be managed. Preservation of family legacy can continue. Long-term governance can also manage. Ease of beneficiary changes, it is also there. So key takeaway is trust offer control, protection, and privacy unmatched by other succession planning tool. They are especially beneficial for families for complex asset, business interest, and cross-border wealth. Because sometimes your business is higher, the other business is low, but you can manage like this, that, okay, both are managing, but his asset, his share is there, so they can do. So friends, today, these are the important things, and we will discuss about the strategy for succession planning through trust. Customization trust, Ravi will explain that what types of trust, revocable, irrevocable, discretionary, special purpose, defining role and responsibility, how the asset allocation can take place, and how the continuity and the professional management will also can take place. And it is not that the this particular concept is new. Entire world is managing this, and so many countries, so many jurisdiction, they are managing this concept of the trust. And that's why we have seen the primary trust type India, private family trust, employee welfare trust is there, United Nations living trust, charitable trust, Europe discretionary trust, family trusts are there, Middle East Sharia compliant trusts are there, and China and East Asia dynasty trust, family charter is there. Then taxation aspects is everywhere. Some advantages there. Regulatory compliance is also different, and that is there. Succession challenges like informal succession process, dispute, tax unpredictability, high in USA high estate tax, legal dispute, that is professional challenges can be managed, family dynamics and religion, that is managed in the eastern part of this, and then professional involvement, technological trust. All these things are there in other part of the world, other jurisdiction. So with these things, today we will discuss all things in detail. Uh, and the most important thing is that listed companies, they are making trust, and then the trust takeover law is also applicable. So you can transfer shares, you can do this, how you can do this, that all will discuss. So today, Ravi will discuss about the entire tax aspects. Manoj will discuss about the taxation aspect, listed company, and the general committee. We have received various questions, and anybody has any issue, they can pass on to us. We will discuss threadbare all your questions, all your issues in today's discussion. Friends, before closing and before saying, I just want to inform you that the knowledge sharing we are doing continuously, and we will do. That is our commitment. And next webinar on 17 January on the Friday, 4 p.m., we are having a program on leaning out of group consolidation and simplification of group structure. That is also a sub route of succession planning, because when you do this, you have to manage this. So now I will request Ravi to give his presentation and explain the entire thing. And I request everybody, I have received various questions, you can pass on to me. We can share with everyone. Over to you, Ravi.
Thank you so much, sir. Although you have summarily covered the entire ecosystem of succession planning through trusts, not only with respect to Indian jurisdiction, but also with respect to America and China, also Europe. Going forward, I'll just give a brief background about the institution of family, why family businesses need specific protection through succession planning, why at all there should be a discussion about succession planning, why is it necessary, and what entails if you do it and if you don't do it. So without much ado, let's go for it. Next slide, please. So as we see, family businesses, colloquially at least, can be called the backbone of Indian economy, contributing more than 75%, substantial percentage to India's GDP. Because they are family businesses, they have usually more than one participant from the family, not only in the execution, but also in the decision making. And therefore, they have their own unique challenges and issues. Not always problematic, but nonetheless, they have their own unique issues to deal with. One of the major reasons for these issues coming to the fore is the generational development of the family, and due to which new generations come in. Coincidentally and unfortunately, the familial structure in India is that the more it progresses, the more distant relationships become. Two brothers born out of same parents, 3 generations back, today their legal ads would not be even the first cousins amongst themselves. That's how it progresses. The more it progresses, relationships become distant. Not only distant, but also there are issues. So it has been observed, and this is particularly called third generation curse, that most of the family businesses, only 13%, they survive the third generation. And beyond third generation, only 4%. So such an abysmal rate of succession. As we know, the family is the oldest institution of mankind. Why I say the oldest institution? Because institution is not only made up of bricks and mortar, it is based out of a common belief system. And in family, that belief system is seen, particularly in India, China also we can say because of the old dynasty system that they follow. But India has its own peculiar and for good reasons, very strong ties within family. And you see, that's why empirically we are third in the world so far as the successfulness of family businesses are concerned. A data shows, as per the CSRI report, India has 108 publicly listed family owned businesses, which makes it ranks third after China, which has got 167 businesses, and USA 121. Can we go to the slide of the family definition? So, what are the strengths of a family business? Shared values and vision, stability, commitment, innovation, flexibility, long-term outlook, decreased cost. There are many more, but just to focus on the key strengths that a family business has. If we come to the landscape of family businesses in India, over 70% businesses in India are family businesses. Out of the top 500 companies, about 60% are family controlled or family led. When we talk about family businesses, there are three concepts when you dig down. They are family owned, family managed, and family led. I'm not going into the fine distinction of between all three, but let us for a moment understand all these as family businesses. They constitute more than 60%. And top 10 family businesses would be having a combined value of 60 lakh crores. And as Sir said, they are projected to grow even further. And the estimations and projections say that they would contribute by 2047, 85% of GDP. So sorry, got mute. So the dominance of family businesses in nations like China and USA, it reflects upon its strategic advantages. Let us see the survival statistics, although I've already told you, but let us see it on screen. Next slide, please. Next slide. Contribution to global GDP is 70%. Then as we talked about, the second generation transition rate is 30%. And at third, from second to third generation, it is close to about 13%. Beyond third generation, that is to fourth generation, is abysmally low, 3%. So it shows the degenerative problem of lower succession rate from one generation to another. That owes to some reasons. Initially, when the when many studies were not conducted, reasons did not surface. But after many studies are conducted, the reasons have surfaced that it is chiefly due to lack of a proper plan, lack of a proper succession planning exercise, that this degeneration happens from generation to generation. And let us see which are the prominent family businesses in India. We all know. Move to the next slide. I think this is optically relatable to the audience. Next slide. Let us see internationally which are the prominent family businesses. We are not covering all of them, but just to give you a knack of what the big players constitute. Next slide. Key or notable conflicts that have happened in past among family businesses. Sir already told in the beginning, so we will not dwell into it. Next slide. So what is the need of succession planning? Why to discuss such a topic? The need is that to ensure the continuity of family business. I think this is the cardinal need and the importance for discussing this. It also promotes governance because you chalk out a way for management, set up the processes necessary to ensure succession planning. Automatically, it will lead to good governance because you're not living, the business is not open to the perils of future moment to moment. Somebody has carefully thought about the future and how the future will be navigated. And therefore, it automatically leads to better governance. For protection of family peace, legacy, and prosperity, uh, those who set up a business, they know what blood and sweat goes into it, how much of midnight oil they burn, and therefore it is always, in my limited experience, whenever I've interacted with a visionary and an enterprising individual, they always think of business continuity as well as family prosperity. They go hand in hand, especially in the case of family businesses. It is always one of the objective, or you may say the twin objective is family business continuity and preservation of the family legacy, reputation, and prosperity. And then the fourth one is more idealistic, that if at all there are conflicts in future, they are converted into, they are channelized, and at least the valuable assets or the business that the family holds or controls, it does not go down the drain. Let us talk about the regulatory framework that attracts when one talks about succession planning. Although the laws that will be applicable on a succession planning exercise will chiefly depend on the nature of the business, industry, sector, the vehicle, or the entity in which the business is housed, and the nature of assets and properties that the business have. We'll just take one by one and it will give a fair understanding to build further on that. Taxation laws, for example, they will apply because naturally a business would be for profit, and therefore some income or asset will arise out of it. Some economic value will arise out of it. And if it is distributed or appropriated, even by tax structuring, even by the route of trust, that will entail some application of taxation laws. Stamp duty laws, because any instrument which transfers or creates or obliterates any right duty or imposes any new right to duty, it requires payment of stamp duty. So therefore, that will become applicable. If the business is being run in model of a partnership, law will apply. If the structuring is done through trust law will apply. If the business is being run in form of a company law will apply and has to be taken care of. If the business is listed or any of the undertaking, any entity of the business is listed, securities law will also have to be complied with and looked into before succession planning is done, because a listed company is not a closely held company. Therefore, it has to be then structured differently so as to comply with law, not only in letter but also in spirit. Sectoral laws, let's suppose if an NBFC is there or NBFC is there, let us take the NBFC example. So therefore, the sectoral regulator, RBI, their policies, master directions, those all need to be seen and complied with. Property and registration laws, if the business has properties and which require registration, especially in case of immovable properties, these laws are to be seen. personal laws. We know that in family businesses, succession planning may also entail some distribution at a future date. So therefore, the personal laws will also govern. And of course, because every business which is worth succession planning would have some or other IPR. Therefore, these are also need to be looked into. So we see that the regulatory framework is ever dynamic, ever evolving, and one cannot give a straitjacket formula what all laws will apply. It will depend on the uh, nature of business, nature of assets, extent of assets, and the parties and the personal laws that are applicable to the parties. So this needs to be very carefully crafted before an exercise of succession planning is undertaken. Let us now see how the succession planning, because today's topic, there could be many, many ways to do succession planning, but the most, you would say the most famous, or in other words, most preferred route is the trust route. So therefore, let us see what is a trust, what all parties are involved in trust, how complicated or simple is it to create a trust, and how and why it is said that the trust route for succession planning is by far the viable route to do so. A trust, without going into the technicalities of law and by decluttering all of them, is a legal arrangement involving the ownership as well as management of various assets. So, as the position of a trust is very, in that sense, very dual, because it has the ownership as well as an obligation of protecting the assets or managing the assets through trustee. It arises out of a confidence which is reposed by the settlor and is accepted by the trust and trustees, and therefore for the purpose of beneficiaries. And this is how the trust comes into existence. In more simpler words, with help of an illustration, if Mr. A wishes to bequeath his properties in favor of his wife, Mrs. B, and their children, Mr. C and Miss D, daughter, one son and daughter, and their children, their progeny in future. So Mr. A will bequeath the property, he'll declare a trust. That trust may have a trustee. Mr. A can also be a trustee in the trust. He can assume more than one role. He could be a settlor as well as a trustee and a beneficiary as well. Or he may appoint different people as trustee, professional, or somebody from the family itself. And that property, whatever Mr. A bequeaths, will be managed for the benefit of the beneficiaries and in terms of the trust deed chiefly, which has to be drawn in accordance with the Trust Act, but it not only limited to the Trust Act, it has to be seen again, as we discussed earlier, nature of business, nature of assets, where the business is nestled, all of it to be seen, so that the proper management of and control of business is equipped with the trust without violating any other law. Because if the trust violates any other law, the other laws will prevail, or the chances of disputes or running into non-compliances arises. So we see the three parties: author, settlor, truster. Truster is not the term we use in India. So author or settlor are the two key terms, you would know it by. Trustee and beneficiary. Settlor could also be a trustee as well as the beneficiary. So one person can take multiple roles in trust. Usually the head of the family takes this role, settles the trust, becomes a trustee alongside other persons, and also is a beneficiary for his lifetime. Next, what are the objectives of the trust? Chief one is the protection of assets. Trusts are used to protect the assets or the businesses or the way the businesses will be managed. By protection, against whom it protects the assets or business? Number one, against any dispute that may arise between the owners. First protection is from that. Second protection from outside external threats. Maybe in a litigation, somebody claiming as a personal liability on someone. So against that also it protects. And lastly, it also ensures that no claim in nature of will be raised against property which is already bequeathed in a trust. So if Mr. A has already bequeathed his property into the trust upon demise of Mr. A, nobody can say that these properties should be uh, uh, these properties should be distributed as per the will or should be treated as forming part of his will unless until the trust deed expressly declares so. And we'll discuss about the types of trust going forward. It may also safeguard to a certain extent in bankruptcy situations, uh, in cases where some sort of enforcement is extended to the personal assets. And it is also a very good measure, apart from the self-acquired properties. Trust route is also preferred to keep and safeguard the ancestral properties. Many people do to avoid any claim in future being made by the successors about dissipation or misappropriation of an ancestral property. Because even the child in the womb of a mother has some right to the ancestral property and may enforce that right upon becoming a major or even while being a minor through a guardian. So, therefore, trust routes are already very famous and in vogue for protecting those sort of ancestral assets, where then the chances of somebody demanding a partition, especially when the property is a heritage property or or last reminiscences of their ancestors, they used to safeguard it like that. So, from the protection of assets point of view, there are multiple protections that the trust offers. The degree of protection may vary from fact to fact, from a situation to situation, but the purpose of protection is not only theoretical, it does provide protection in real life instances also. The accuracy of control or the autonomy of control it provides. Once nestled in the trust, there the confusion regarding control, which is in itself a very elusive concept. And the word has a polysemous meaning, which means in different contexts and settings, it means different things. Control, just to give you, will not dwell into the topic of control because in itself is a topic worth covering in a series of webinars, not even in one webinar. But the word is polysemous because there could be an exclusive control in certain settings where the control means exclusive control. In certain settings and context, it may mean joint control. In certain settings, even management is control. How to determine that control is also a question to be analyzed. So it is very elusive and a fact-finding exercise. Therefore, to avoid all that confusion, how the control can be automatized is can also be achieved by the trust route. Because in trust, the deed will determine who will have control, and by law, trustees ought to have control of the trust and the properties therein. So, therefore, having succession planning through trust route and in the trust deed also providing for proper succession planning for the trustees ensures that the control is automatized, including its succession. There is a very big group, I would not name it, and it is embroiled in litigation for last 2 decades. Only because they are not able to determine, and there are claims from both the sides, rather, there are multiple sides in that issue. From all the sides, the claim is that we hold the control and not the others. And the courts have not been able to decide it yet. The matter is still pending at at an appellate stage. So this is how it bypasses the assessment of control and automatizes it. Preservation of family wealth. When clear succession planning is demarcated, although I must concede that it cannot always be in black and white as one would like to, because the nature of the business, the landscape of business is so dynamic. One cannot, with all certainty, assure a certain future. But it does provide you a life vest when an emergency situation arises. And sometimes that life vest is enough to save a life. So therefore, it does provide for situations where there may be conflict between the family members or the persons who claim to be owners, and may provide for a dispute resolution mechanism. Even better, it may provide for such a succession planning that such a dispute will never arise. As Sir gave examples of some prominent businesses, how they could have retained the brand under a common umbrella and worked for it for the betterment of the brand rather than competing with each other and getting into SAR litigation. So I would say not only wealth, but it also protects the family reputation and name. What are the benefits of having a private trust? Just to halt and explain, whatever we are talking today is about private trusts. There could be, when we talk about trust, there are many categories. They have many color and hues. But there are chiefly two types of trusts. One is what is called private trust, and the other is public trust. We are talking today about private trust. Public trust are those trusts in which beneficiaries are public at large without any discrimination based on caste, creed, religion, color, or any other, so to say, illegal classification. We are talking about private trust in which beneficiaries are determined or at least are determinable and need not be to be the public. They could be a selected pool of beneficiaries, which, and in from the context of family businesses, we are talking about the private trust. So what are the benefits of having or creating a private trust? We talked about protection of family assets, efficient management of family assets. Now, as a very famous philosopher, Jiddu Krishnamurti said, word is not that. Merely because you have a trust, it will not ensure all these benefits will be endowed to you. One needs to very carefully think about how a trust is to be structured. The major role which is played if one wishes to gain all the benefits out of trust based succession planning will only be determined or will only be able to get if the trust is curated that way, keeping into mind all these objectives and with clarity of thought. And with that, what one can get is more than what one can wish. Protection of family interest, efficient management of assets, minimizing disputes, centralized control of family business, probate-free transition, as we discussed, because question of will is ousted once all the properties are bequeathed to trust. They do not remain private personal properties unless until the trust is revocable. Once again, we'll discuss it once we discuss about the trust. Unless until the trust is revocable and the settlor has revoked the properties back during his lifetime. Therefore, the trust is revoked, in other way. So it ensures probate-free transition, protection against insolvency risks. Of course, the terms are customizable, and rightly so, they must be customized if one wishes to get benefited from the succession planning. Flexibility of structure, again, also a benefit and a caveat that the flexibility must be utilized to the full extent, and privacy. Because only the beneficiaries have got the right to ask for the accounts of the trust as per section of, I'll just come to the section. Only a beneficiary has got right to ask for the accounts as per section 19 of the Indian Trusts Act. So not that any member of public can go to a website who has got no concern with the trust and download its accounts and statements. So formation of trust. How a trust is formed is created, or when a trust can be formed. A trust can be created for any lawful purpose. What needs to be done is a simple declaration. Well, only when I say it is simple, but when it is used for the purpose of succession planning, as I said, one needs to very carefully ponder over the objectives. But the declaration, the process is very simple. You have to chalk out a trust deed delineating all the provisions that you would like to keep. Like Contract Act, Trusts Act is also an enabling law. It only tells you the four corners, the periphery within which you have to play. But within that periphery, consider it's like an ocean. There is a whole lot of area to structure and fulfill your objectives, create terms that fulfills your objectives and furthers them. And a formal written document is not even necessary. That's a very old view, but still holds good. And trust may also be created by a will of an author. These kind of trusts are called living trusts. So what are the type of trusts? One is a specific trust. These kind of trusts are the trusts where the returns or the shares of the beneficiaries are determined by the settlor, and very commonly in the trust deed itself. The trust deed itself provides for what would be the extent of benefit that a particular beneficiary is going to get out of the trust. Discretionary trust you can understand in a simple way that it is exactly opposite to the specific trust. Here, the discretion is with trustee when and how much to allocate to each beneficiary. Irrevocable trust, as the name itself suggests, is a trust which cannot be revoked by the settlor, which means once created, can never be revoked back. It will continue unless until the trustees, by following the process laid down under Indian Trust Act, wind up the trust. Deemed revocable. These are the trusts which are deemed revocable and can be revoked by a settlor, which means a trust is created. Revocation means a trust is winded down. Testamentary trusts. These are also trusts which are made for the purposes of passing on the assets and wealth to the successors upon death of the settlor. And there are many other types of the trust, but chiefly these 5 types we will discuss. Let us see what are the steps for implementation of trust. So, as we discussed, one contributes to the assets of a trust, which process is also called as declaration of trust. So the settlor declares that I hereby am bequeathing certain and certain sum of rupees or certain and certain schedule of assets into a trust. So and so will be the trustee of the trust, and the name of the trust shall be so and so. And this itself creates the trust. But friends, by this, I do not mean that it is an exercise which can be done merely by writing these 3 statements. What the devil is in detail. And if it is meant for a purpose as complicated and as benign as succession planning, there must be a thorough application of mind for creation and implementation of succession planning through trust. So settlor then appoints a trustee. From purely procedural point of view, trustee specifies who are the beneficiary, their share, or in alternate, it specifies that it's a discretionary trust. What is the legal effect of creating a trust is now on the second layer of the presentation, which you see on your screen, is that trustee becomes the legal owner and is obligated to manage the assets for the benefit of the beneficiaries. Let us quickly, when we are discussing about the trustee, let us quickly also see what are the duties. Section 11, trustee must fulfill the purpose of the trust. It is a statutory duty of the trustee. and has to follow the directions of the settlor. Does not mean the oral directions, but the directions that the settlor has given alongside the bequeathing of the property that has to be followed by the trustee. Of course, the declaration or the instruction of settlor cannot be itself illegal. In that situation, trustee is not bound to follow it. Section 15 says that the trust must manage the trust property as carefully as a prudent person would. So the rule of prudent person, the test of judging the acts of trustees are the test of prudent person. Then trustee cannot benefit or profiteer from the trust or from the position that he holds qua the trust. And trustee must take all reasonable steps to preserve trust property. It also specifies what are the specified investments for a trust, but the trust deed that is scalable, and this is only indicative. And then it says that the trust must maintain accounts, which accounts cannot be seen by everybody, all and sundry, but only by the beneficiaries of the trust. And then section 17 again relegates it back to the trust deed, as we have been discussing for quite some time now, that the trust must distribute the trust income as per the terms of the trust deed. So this is about the trustee. What are the duties and obligations of the trustee? What all assets can be put into a trust? Now let us also understand it. Assets could be movable or immovable. All sort of assets can be put in a trust. Intangible, tangible, valuable, invaluable, ancestral, self-acquired, all sort of assets. There is only one fetter. One cannot declare or bequeath an asset to the trust which one does not own or which is encumbered. Something which is already encumbered in the terms of encumbrance provide that before declaring or creating third-party rights, one must obtain NOC. Let's suppose a property that is secured with the bank against a loan and the charge is created and the loan agreement says that no third-party claim should be raised on this. So the gentleman cannot unilaterally declare it into the trust. That is the only fetter. If the property is unencumbered, regardless of the nature of the property or the value of the property, it can be bequeathed to the trust. One can have in a single scheme of succession planning, it need not to be implemented through a single trust. There could be multiple chain or level of trusts, each working as apparatus of a larger machinery, each one playing its own role in protecting, furthering, and managing the business as well as the assets at a conglomerate level. So, and we will see the example and we'll listen on this topic more from Manoj sir. Then there could be, again, in the single and multiple trust point, there is also a point that there could be different layer of trusts. One could be master trusts. One could be under the umbrella of a master trust. There could be certain sub-trusts which are functioning in tandem to achieve a common objective. And these sort of trusts become really helpful where multiple generations of family, which are very distant from each other, each handling their own set of businesses or undertakings or a geographical area or a particular product, all sort of combinations as there can be. In those situations, these can be tied back to a master trust with each sub-trust acting as a contributor to that master trust, or each sub-trust acting as a receiver from the master trust and then distributing to the faction of people it represents. So that sort of layering can also be done. Then there could be different trustees and beneficiaries. It's a no-brainer. And then execution of trust deed under the applicable law. So once you put all these things together, then the trust deed can be executed, which means it is sent for registration and for the purpose of creation of the trust. Let us see what a simple structure of trust look like with an optical example. So you see at the top is the settlor who vests the property in the trust and conveys the legal title to the trustee. The trust is created. what the trust is holding is the assets right at the bottom of the chart. If you see towards the left of the chart on the screen, is the trustee who holds the legal title and the obligation to manage the trust assets and properties. On the extreme right of the chart are the beneficiaries, means the persons for whose benefit the trust is created. Now, this is a very simple structure of a trust. Let us see not the most complex, but a little more complicated structure of a trust. And it could be made very complex only optically, but to serve and to cater to very complex purposes and very complex situations. Let us see this situation, and the objective is here. Let's suppose the person who creates the master trust. So before I go on to explaining, what you would see in this diagram at the bedrock of the chart, right at the bottom of the screen, are three boxes. One is operating company, second is other investments, and other assets. These are the three things. Let's assume one entrepreneur has these three category of assets. He creates a master trust. Which master trust is holding and legally owning all these three assets? The entrepreneur has got two sons, and both of them have their own families. So he then creates two trusts again with both of his sons separately in both of the trusts, son 1 trust and son 2 trust, which are holding 50% in the master trust. So as I said earlier on the last slide, they are acting, these son 1 trust and son 2 trust are acting as receivers or the beneficiaries of the master trust. And these two trusts are discretionary trusts. Son 1 has got discretion, if he is the trustee in that trust, to distribute the property further with his own family. In that trust, the enterprising individual, who's the settlor here of the master trust, he has got no interference in that trust. And similarly for the son 2 trust also. So you see what has been done here is that the leader or the settlor, the family head, has ensured all the assets are protected in the master trust. They are managed as per the trust deed. Maybe son 1 and son 2 are also directly managing those assets. But son 1 and son 2 are not directly claiming through those assets. They cannot partition those assets amongst themselves. There can be no claim on those assets even by their successors. They can only receive income and benefits in their respective trusts from the properties without dismantling the properties themselves. Is the whole objective of succession planning. In simple words, it is like extracting nectar of the flower as the honeybee does without ruining the flower itself. I think the most simplest explanation I can give is that. Let's go to the next slide, which is about registration of the private trusts. If it involves any immovable property, the law is same. It requires registration. Only exception is if the bequeathment is through a will. If it is a living trust, it does not require any sort of registration because it acts as a will. A will does not require stamp duty at the time when it is declared. The word declared is not used in the sense of will because the will is the most confidential thing one would like to keep unless until one passes through the journey of life. So therefore, the will does not, if a trust is created under a will, registration is not mandatory. Else it is mandatory if it involves movable property. In case of movable property, registration is not mandatory. Movable property includes cash, investment, or other personal assets. Then what are the documents required for registration? Of course, trust deed, identity and address proof of settlor, trustee, and witnesses, and details of properties being transferred to the trust. So the procedure remains by far the same as in case of a normal transfer of a immovable property. Next slide, please. Lastly, before handing it over to Manoj sir for enlightening us with the taxation part of the trusts, there is another important thing. Well, stamp duty is also a tax with a different name. What are the stamp duty incidences on private trusts? When a property is transferred to a trust during the settler's lifetime, it will attract stamp duty. And that stamp duty does not have an exception for movable property as we saw for the registration. Registration in case of movable property is optional, but stamp duty does not confer any such benefit for movable property. So even those are liable to be stamped. If they are being transferred through an instrument, so the key ingredient for testing whether a stamp duty attracts or not is whether there is an instrument or not, as per Section 3 of the Stamp Act. And amount of stamp duty, as we all know, it's a state subject. The central legislate and the state can also have their own laws with respect to stamp. So it depends on state to state, nature of instrument, and it has to be paid to the local revenue department or via authorized bank or authorized channels in case a specific sort of asset is involved where the payment of stamp duty is designated to a particular authority. So that's all on the this ever dynamic and very important topic as we are moving into a more mature realm of Indian businesses, which are ever increasing, even beyond the horizons of the so-called traditional countries where we used to conduct businesses. And because we as a country have matured, we are now 75 plus. Therefore, rightly at this time, we require succession planning. Over to you, Manosa. And before that, to Pavansa.
Thank you, Ravi. Thank you very much. Manoj,
Yes,
Ravi
sir.
has covered the entire gamut and I have given the background. Now, something which is missing out, please tell, number one. Number two, you just tell about the listed company. Because unlisted company trust is, you have to follow the trust route, all these things. So for listed company, additional responsibility is the SEBI law also, and specifically takeover law.
Yeah.
So when there is a trust, you are transferring shares one time to trust. What are the things? Okay, and then you have to cover the tax liability also. So I have first time I'm making a trust, transferring my asset. What is the takeover law? As I say, interest transfer, how it can be taken place. Tomorrow in the trust, you are transferring shares to another group, okay, to settle something or something. You have to fulfill the terms and condition of the trust that after some time, some new member has added, then you are transferring, some member has attained the age of 18th, okay, he has 18 and 21, whatever, as per the trust deed. So you have to tell all these aspects of taxation in SEBI law and the general aspects on what you think about this particular concept, why this is becoming popular. And sometimes the question is, if my data is saying 75% companies are not having a succession planning, that include listed company also. In the listed company, we are seeing very few companies that they made a trust and they are doing this. So please light something on these aspects.
Yeah, thank you, sir. I think Ravi has given a very elaborated discussion on how the family businesses are run and how succession has happened and planning is done in some cases, and some cases it is not formally done, and how the private trust can be very beneficial in ensuring legacy of the family goes from one generation to another without any much dispute. So the basic thing is, through private trust, a rule-based management of the assets of the company, property of the company or business is ensured. It also ring fences the assets or wealth of the company or the person who entrepreneur from various regulatory actions, maybe sometimes matrimonial disputes, family disputes, then inheritance taxes, which is presently not in India, but if the persons are, some are outside India, NRIs are there, or some family members shift outside India and directly owns through inheritance, they may get tax liability in different jurisdictions. So all those protections are there, and hence it becomes more and more relevant in these days when the person's business families have accumulated good amount of wealth and they want continuity of the business, continuity of legacy, and the wealth of the family for long-term prosperity of the family. So one of the important aspect, as we all are discussing, people want to understand that what kind of taxation advantages are there if we are transferring the assets to a family trust. So if in principle there is no advantage or exemption to a trust to businesses which are owned by some family trust, but it makes the life simpler for the family members. There may be different family members having different kind of income. If it is owned by individually, they may have different tax slabs, different tax regime, but putting the assets into a family trust may make the life simpler, because the trust becomes the representative assessee for entire family members. So let us discuss first the taxation aspect, and then I will also try to discuss the family trusts which are being created by various listed companies promoter, and they are transferring their shares in a listed company into family trusts. Okay, so both the aspects I will try to cover. Hope my presentation is visible. Yeah, so
Yeah, it is visible, Manoj, now, or you have to go for slideshow.
yeah, sure.
Yeah, ठीक है,
So first, taxation aspect of private trust. So broadly, if we say that there are two type of trust in case of private trust. One is revocable trust, and other one is irrevocable trust. Revocable trust is very simple. It is such a structure where the promoter, the settlor of the trust has a right to take the assets back. If such kind of structure is created, then it is not a permanent trust. It can be anytime dismantled by the settler himself. So in such cases, the taxation would be in the hands of the settler. And the rate of tax would be as applicable to the settler. It will not be anyway different from in normal course when he was owning those assets. But that kind of trusts are very limited in vogue, because it has not much benefit of creating such kind of trust. The other one is irrevocable trust, where the assets are transferred to a trust and the assets are managed by the trustee and for the benefit of the beneficiaries. Beneficiaries may include the trustee, settler himself,
इसको भी हटाता हूँ.
or sometimes the settler may also be one of the beneficiaries, and sometimes the settler may be the trustee, one or more of the trustees. So in such cases, there are specific tax law we will discuss in detail. But the broader aspect is in all such cases, in case of irrevocable trust, the income of the trust, which includes all kind of house property income, investment, capital gain, etc., all are taxed as per the tax rate applicable to the individual who are the beneficiaries of the trust. But in case it is a business income, if there is a business income into the trust, then it is and the trust is indeterminate trust. In both the circumstances, the tax rate will be the maximum marginal rate. Maximum marginal rate is the maximum rate at which income is taxed in India, so which is around 30% right now, plus surcharge or cess, as the case may be. So we will discuss one by one. So in case of irrevocable trust, trustee will be considered to be the representative assessee. So he will determine the liability on behalf of each of the beneficiaries, and based on the collective amount, he will deposit the tax liability into the account of the government, and the beneficiaries would get the tax-free income post that. The other one, so liability of the trustee, in case of this kind of irrevocable trust, the trustee becomes liable to pay the tax, and hence it is though he is the representative assessee, but he has to determine the tax, he has to deposit the tax, and all kind of liability becomes his personal liability in case there is a default on his behalf. Uh, in case of irrevocable trust, the if the beneficiaries' interests are not determined, different the trustee has the right to determine the distribution of the income from the assets bequeathed in the trust. Then in such cases, the rate of tax would be the at maximum marginal rate. Trustee would be responsible to deposit that much tax in the government tax department, and then the amount which is left out can be distributed as per the discretion of the trustees, as per the trustee, as the case may be. Here again, the question comes if there are different beneficiaries, and as we discussed that the trustee is the representative assessee, he has to determine what kind of tax liability each of the beneficiaries should have, and how, and accordingly he has to determine the tax liability and deposit in the tax. So residential status of the trustee and beneficiary becomes sometimes very important. So in case the trustee is the residential status of trustee is the same as of the beneficiary, then there is no dispute. It is a very simple thing, and based on the beneficiaries' residential status, all beneficiaries are, if Indian resident, then the tax rate as applicable to Indians would be applicable. But in case all the beneficiaries are outside India, the tax liability would be different. Tax liability on transfer of assets by the settlor to trustee. This is another aspect which comes to the picture at the beginning of the creation of the trust. So there will be an exemption under section 47(3) of the Income Tax Act, where settlor transfers assets to the trust. However, it is very much, we have to understand that this exemption is only with respect to the benefit of the family members whom shares or assets can be transferred without any capital gain liability in normal circumstances as a gift. So if all the persons who are the beneficiaries of a trust are eligible to get gift without tax, then the transfer of assets into the trust for the benefit of those trustee would be those beneficiary would be fully tax free at the time of transfer. In case we are talking about the taxability of transfer of assets in the hand of the trustee, so there are judgments which says that though the trustee would get the assets, but they become the literal owner of those assets, and they manage the assets. However, the liability they are taking to distribute those assets or manage those assets is sufficient liability, and hence no duty need to be paid, no stamp capital gain tax under section 56(2)(10), which is deemed gift tax, to be paid at the time of transfer of assets. However, there are, as I discussed, unless if there are certain beneficiaries which are outside the family members, or who are not exempt under the gift law, then there may be a tax liability in the hands of the trustee. Some judicial pronouncements are very important. One is relating to Moti Trust Kota versus Commissioner of Income Tax Jaipur. Even if the trust is regarded as discretionary trust, it is the beneficiaries whose hand that income would be assessed. So in case of discretionary trust, in normal circumstances, we have discussed that the tax liability would be at the maximum marginal rate. However, under this judgment, it is being said that in case of discretionary trust, where the trustee has the right to distribute or not to distribute, or determine the ratio of distribution, still trustees are the representative assessee, and hence the liability would be limited to, or to the extent of the beneficiary's liability as per the income tax slab they are applicable to. Similarly, there are other Supreme Court judgment which says assessment against the minor minor beneficiaries of a trust would not be applicable. However, trustee would be taxed, because trustee is the representative assessee and he should be taxed. A recent judgment of ITAT Karnataka, which says that the tribunal agrees that the trust was not solely for relatives. So as I discussed, if there is a trust where the beneficiary are not the relatives of the settlor, in such cases the trust should not be the transfer of assets should not be exempt under 56(2)(10), and hence there may be a liability in the hands of the trustee. So these are there are hundreds of judicial pronouncements, and the law is quite complicated. However, in some simple process, if there is an irrevocable trust, the assets getting transferred into the trust would be tax-free. If the beneficiaries are the family members or relatives who are otherwise exempt under the gift law, gift taxation provisions. In all, and the rate of tax or the liability of tax would be to the extent of the beneficiaries' tax slabs as applicable. And in case of business income, it is taxed at the maximum marginal rate. Rest all others are very complicated things, so it is not simple to discuss in the presentation. Each cases we have to assess, and based on that we have to determine. I think there are certain other laws which need to be kept in mind while making that asset transferred into a family trust or private trust. So company law provisions like significant beneficial owner disclosures are required. So who are the trustees, and trustees' power to control the assets, control the shares of a listed company or unlisted company, as the case may be, would determine significant benefit ownership disclosure. Similarly, SEBI's takeover regulation, which is SAST regulation, is also one of the key element in case the asset involved the shares of a listed company. I will discuss in detail. Then there may be certain FIM aspects, like I have discussed. Some beneficiaries may be outside India, or some in some cases trustees may be resident outside India, so there may be a need for approval from Reserve Bank of India, and the jurisdictional tax aspects, inheritance tax aspects, etc., need to be considered while framing or transferring the asset into a trust. So let us now discuss trust as a promoter of a listed company. We have seen recently that many of the family-owned businesses or listed are in the form of listed companies, and the promoter want those assets or those shares need to be transferred to some family trust for succession planning purposes, or for even for avoiding or reducing the tax liability in case the inheritance tax comes into picture. So we have seen many cases where a family trust is inserted as a promoter of a listed company. So let's discuss what is the legal position under the SEBI law, and how to make a family trust as part of the promoter group. So, as I discussed, the most important aspect of the SEBI laws are which is applicable in case of transfer of shares of a listed company, is the SEBI takeover regulations. So, what are the trigger points? So, here, in case shares of a listed company's promoter is transferred into a family trust, whether open offer would be triggered, and whether there is an exemption available because all the members of the trust beneficiaries are family members, and otherwise they are exempt from the takeover open offer obligations. So let's discuss the trigger points. So under that SEBI takeover regulation, there are three major trigger points. One is Regulation 3.1, which talks about the initial threshold of 25%. So whenever a listed company's 25% or more shares or voting right is transferred from one person to another, it triggers open offer obligations. So 25% includes obviously the person who is transferring along with the person acting in concert. The other aspect is in case a group of persons or promoters are holding 5% or 25% or more shares already, and they want to acquire further shares. So there is another threshold, which is the 5% for each financial year. So any group of persons or promoters holding 25% or more, but less than 75%, can acquire 5% additional share every financial year without triggering the open offer obligations. The third thing is obviously Regulation 3.3 is there, that it says that in case the two threshold, that is the 25%, the initial threshold, and 5%, which is consolidation threshold, which comes every financial year for larger shareholders. would be considered on individual basis as well as aggregate basis. So we have to check this while determining the obligation to make open offer open offer. The third one is more important, which is relating to control. So acquisition of control, irrespective of percentage of shares getting acquired, would trigger open offer obligation. So here, this is the tricky aspect. Here it is not talking about how much percentage would trigger. So if there is a control, so control, what is the control? Control is defined as a right to appoint majority of directors, right to control the management, and right to control the policy decision making of a company, of a listed company. In case any of these things happen or is with someone, that person is known to be in control. So all the promoters, irrespective of their percentage holding, are considered to be in control of the of a listed company. Now, when we are talking about the family trust, if the family trust is not part of the promoter group at the time of listing, initial listing, and it is being inserted into the uh, part of the promoter group, irrespective of the percentage of holding, whether 2%, 5%, or even lesser than that, and it is being part of the promoter group, that means they are bringing, the promoter is bringing one new person into the control system. And control is always not individual, but it collective thing. So it may be considered to be a single to joint control. If let's say there is only one promoter holding, let's say 70% equity in the company, now he want one family trust with 2% share as part of the promoter group. Then here there will be two promoters. One is Mr. X and another is the trust, family trust, who are jointly controlling the company. So it can also be a trigger point. So there are certain automatic exemption given from the takeover open offer obligations, and those obligations are provided to transfer among the immediate relative of a family. So if A is Mr. A is the promoter of the company, and he transfers certain shares to his son, daughter, or wife, etc. So all the immediate relatives, as prescribed under SEBI takeover regulations, would get the shares without triggering the open offer obligation, irrespective of the percentage or threshold getting triggered. Then if there are two group of promoters who are holding or continuing to hold shares in a listed company for 3 years or more, and they want to settle or transfer shares among themselves, then there will be no takeover offer obligation. Similarly, there are certain group companies which are controlled by the same set of people by more than 50% shares, and the shares are getting transferred among them or by individual to such companies. All such transfers are exempt from takeover open offer obligations. So in elaboration, it is given. However, as we see, the family trust or trust, private trust, as the case may be, is not considered to be a relative. Neither it is a controlled entity, group entity. So they are not automatically getting exemption based on immediate relative definition, nor they are getting exemption because of group company group. So we can discuss that in detail, the definition of promoter. So promoters definition under takeover regulation is referred to SEBI ICDR regulation, which governs the IPO or listing of a company. From there, it is referred to be persons, as we have already discussed. So in any case, if a person is part of the promoter group, and which includes person, their immediate relatives, or any body corporate, subsidiary or holding company, any body corporate which is controlled by the same set of people. So all such kind of people are considered to be part of the promoter group. If someone is already part of the promoter group, then transfer among them or insertion of that person into the promoter group category would not trigger open offer obligation, because that is by default. But family trust or private trust are not covered under the promoter or promoters group definition automatically, and hence they are not getting exemption. So whenever a family trust want to be inserted into a promoter group category of a listed company, it would trigger open offer obligation without seeking exemption from offer. So the only option left is to seek exemption from SEBI before inserting a family trust into the promoter group of a listed company. And hence there is a specific provision in the regulation 11 of SEBI SST regulations, where any person can approach SEBI and ask for exemption, giving grounds or exemption. As we have seen that there are many companies, many listed companies, which were seeking exemption, such kind of exemption. SEBI has provided a detailed guidelines to give grant exemption to family trusts, because they understand that this is a need of the hour. Many promoter want succession planning to be inserted in the listed company, and that is also good for the benefit of all the investors of such listed companies. So conditions for seeking exemption to a trust, SEBI has prescribed certain conditions. Trust is in substance should be only the mirror image of the promoter group, promoters holding. So they want, if the trust is being created by Mr. A, it should be owned, or beneficial owner of those shares should be Mr. A, or his or her lenient descendants or immediate relatives, so that they are all exempted from the conditionality. The beneficial interest of the beneficiary in the trust shall not be transferred, assigned, or encumbered in any manner, including by way of pledge or mortgage in future. In case of dissolution of the trust, the asset should be distributed only to the beneficiaries of the trust, which are or their legal heirs. Then the trustee shall not be entitled to transfer or delegate any of their power to any person other than the one or more of them of themselves. So professional trustees are not allowed. SEBI does not promote professional trusteeship in case of private trusts who are becoming the promoters of the promoter group of a listed company, because they believe they think that SEBI thinks that in such cases the control goes to some private party, maybe sometimes some law firm or other private bodies, which is getting inserted into the control system without open offer obligation. So at the time of exemption, they want certain undertaking, and those while granting such kind of exemption. The change of the trustee or beneficiary, or any change in the ownership or control of the voting shares shall be disclosed within 2 days as per to the stock exchange and SEBI. The ownership and control of the shares and voting right will be treated as vesting, and not only in the trustee but also indirectly in the beneficiaries. The liability and obligation of individual transferors will not change or get diluted due to transfer, etc. So these are the basic exemptions they want, and also they want the confirmation on annual basis by independent auditor that they are complying with the requirements as prescribed under these guidelines. Also, there are certain other conditions like proposed acquisition is in accordance with the provision of the Companies Act. The transferor are disclosed and the promoter in the shareholding pattern filed with the stock exchange for a period of 3 years prior to the transfer. And there is no layering into other terms of the trustee. So like Ravi was discussing, there may be a complex structure of the trust, but in case you want to transfer listed companies share into a family trust, private trust, it should not be layered, multi-layered, so that there is a complex structure and it is difficult to determine the ultimate beneficiaries or the persons who are controlling those shares. Say we want clean structure. So it is advisable, in case you have various properties which need to be transferred to a family trust, which includes shares of a listed company, then to keep the shares of a listed company in a separate trust, and all other assets may be kept in separate separate trusts, so that SEBI's exemption is applied for in case of the simple structure where there is no much other assets and no complications. So if all these conditions are fulfilled, the exemptions are granted, the trust is in substance only the mirror image. So obviously the condition is that family remain with the assets remain within the family, within the control of the family members, and post dissolution asset is distributed among the family members only. So this is all about the legal requirement relating to the transfer of asset into the trust, specifically the shares of a listed company. Uh, yes, we have seen many of the recent time, many of the families have applied to SEBI, like Dr. Reddy's family, Jubilant family, Adani family. All those have applied to SEBI for their exemption, and they have got the exemption to transfer the asset into the family trusts. I
But
think.
Manoj, there are family trusts, irrevocable or professional trusts. There are some issues
Yeah,
which we have faced in various cases.
right.
So in the Dr. Lady laboratories also, they have some issue. The company wanted some different way, but SEBI was not agreeing.
Yeah.
So what was that? That
So,
also.
three things we have while doing our representation to SEBI, we found that first, SEBI does not allow professional trustee. So they want trustees should be at least two trustees, and those should be part of the family of the promoter who is transferring the settlor. So settlor himself, herself, or her linear descendants who are immediate relative of the trust settlor should be the trustee only. That is the one condition. Another thing is they want registered trust. So though being of movable property, listed company share being movable property does not require legally a registration. However, SEBI want registered trust so that there is a non flexibility in the structure, and that is public document to get verified. And third, they want no layering. So there should be only one trust directly owning the assets, and distribution beneficiaries should be determined. So these three things were very important aspect while granting the exemptions.
Okay. Ravi and Manoj, thank you very much for giving a detailed presentation and detailed analysis of each and every aspects of the tax, listed company point of view, the takeover issue, exemption point of view, and Ravi has explained about the formation and what types of trusts. Now we have received more than 35 questions, and I want to give answer of all questions. Okay, so we have to be very brief, but we will want to cover all the questions. Okay, now Manoj, what are the tax benefit associated with creating a trust?
So, sir, as I discussed, there is no direct tax benefit as such. Obviously, the transfer of asset from that settlor to the trustee at the time of creation of trust is generally exempt from takeover income tax because beneficiaries are relatives. But if they are not beneficiaries, then there may be a tax implication in the hand of the trustee. So
Okay.
there is no exemption. Later on also, there is no exemption because the trustee becomes the representative SSC on behalf of the beneficiaries. So there is no exemption directly. However, in case of succession, in case of inheritance tax comes into picture in India, which was earlier but now not there, and which is available, which is applicable in many of the foreign jurisdictions, which goes up to 50% in many of the cases. This can be a very good structure for exemption, seeking the exemption.
Okay. What are the implication of recent ITAT decision regarding taxability of private trust under section 56(2)(x) of income tax, particularly when trustee have the discretion to admit non-relative as beneficiary?
Yeah, so as I have discussed, 56(2)(10) is the tax, basically gift tax law. So that gives exemption from exemption to do the transfer of assets from one person to another in case they are immediate relative or certain other class of persons. So here case was relating to transfer the discretion of the trustee to give the benefit to certain persons which are out of the system of the immediate relative or exemption category as prescribed under section 56(2)(10). So here the ruling says that in case there are outsiders who are getting the benefit of the trust asset, then it may be taxed.
Okay. Now, first question is, would the cost of running the trust would be commensurate with the value of the asset under it, or would it be more fixed in nature? I understand the setting of the trust has one-time legal and professional cost. Ravi?
Of course, the administrative expenses for keeping track of assets and all, they may increase with the enormity of assets. But the cost does not, really escalate with the how many assets you put in a trust. Especially if the trustees are family members, they usually there is no hidden cost with making of trust. So the cost-centric approach would not be the right point to start from. What you need to see the other plethora of benefits that arise. And the first benefit is that you ensure business continuity beyond your lifetime. That's the biggest benefit it offers.
Okay. Is letter of wishes by settlor binding on the trustees?
Not always. It has to be within the four corners of law. If the name itself suggests it's a wish, and so far as practicable, the trustees will comply with it unless until they are made part of the permanent covenants of the trustee.
Can trust own agricultural land?
That
I don't think there is any problem. Yes, family trust can own family assets, so agricultural land is
Okay.
also family asset.
Is the private family trust considered a revocable trust?
Not by
it can
default.
be. It may be, may not be.
It may or may not be.
By
That depends upon.
definition, it does not become a revocable trust. It could be irrevocable also.
Can the settlor also serve as a co-trustee of the trust?
Yes.
Yes.
How can succession planning be structured to ensure that the settlor does not relinquish control over the asset during the lifetime?
We cannot go beyond the trust deed. So if the trust deed says that the control has to be preserved within the board of the trustees or with the trust, and there shall be no divestiture of a particular asset, it cannot be disposed of.
Yeah, so certain veto rights may be given to the settlor with making him as a managing trustee while his life. So that kind of structure can be created so that he remains in control of the many things. At least negative control remaining.
Okay. Is it possible to create such a trust orally? Additionally, if the trust includes a movable property, would it require registration and would stamp duty need to be paid on?
If it involves immovable property, it cannot be oral. It must be in writing. Otherwise, an oral trust may be created, but it will not be much different than an oral agreement. You'll have to prove it when it comes to any dispute. So always advisable to keep it in writing.
Okay. Is bequeath the settlement to trust same?
Bequeath and to testament.
Yes. Bequeathing in the trust and declaring a trust are the same thing. They are
Okay.
with only pedantic differences.
Could you please elaborate on the purpose and objective of having different layers of trusts?
So would you like to take it up?
So it is just a matter of planning. So how they want to, like you have given an example where there were certain assets which the settlor wanted to be in continuity, and hence irrevocable trust, non-discretionary irrevocable trust was created, and rest the family members were allowed, the two sons were allowed to have their internal family distribution as per his will. So this kind of structuring is valid, and it is done in many of the cases. So certain assets may be fixed, and maybe certain part of the assets may be kept variable. Distribution ratio may be kept variable or to the discretion of the trustee. That is
Hybrid
possible.
trust.
So hybrid kind of structure can be created.
Yes.
Okay. Could you please elaborate on the does trust structure in India has concept of protectors?
Yes, it does. It does. There
Okay.
could be protectors. I mean, trust deed, it is very flexible. You can introduce as many concepts as one want to, provided they are not illegal or prohibited by the law expressly.
Okay. In case of immovable property, the transfer has to be registered with the registrar.
Yes.
Other than in case of will, transfer through will.
Yes. That is not to be.
That is not required to be registered.
Correct.
Okay. It is advisable to first execute a registered will and then transfer immovable asset to the trust upon the settlor's death.
Only if it's a testamentary trust. But if one wants to ensure continuity or the purpose that Sir said, that without allowing the beneficiaries to dismantle or directly deal with the asset, they only get the benefit from the asset or incomes from the asset, then a testamentary trust will not serve the purpose, because will only come into effect once the person has passed away. Till that time, who will give the bread and butter to the persons? Who will give the income? So, will trust is suitable in certain cases. In others, it might not be suitable. The purpose has to be seen.
Can such trust be bequeathed to the testamentary trust through a will?
It can be.
Okay. In what is meant by transfer through an instrument when talking about stamp duty on immovable property in a trust?
So let's suppose there is a family of four brothers. Four brothers, in presence of their father, they agreed upon an understanding that they will handle particular blocks of the assets or businesses that they have in the family. And they are handling it without reducing it into writing in form of an agreement or a deed. That there is no instrument between them. So oral agreement is not an instrument because no instrument has come into existence. But the moment they execute it in form of an instrument to divide it between themselves, stamp duty attracts. So that is you must see the querist must look through Section 3 of the Stamp Act to read the definition of instrument and how it has been interpreted by the courts over time.
Manoj, in case of asset, example listed company shares held by promoter is bequeathed to a testamentary trust, how to deal is a transmission particularly concerning compliance with SEBI takeover regulation when professional trustee manage the trust affair?
So, testamentary trust, obviously, we have not faced such kind of thing, but generally, in case of succession, in case of death of demise of a promoter, the shares goes as per the will, and whoever is getting the shares as per the will is considered to be in the shoes of that promoter. So here the trust, if it is being created as part of the will and getting shares post his demise, I think then section regulation 11 would not trigger, and the trust will become the asset owner post this, and trustee, maybe a professional trustee, may continue to own that asset. But then in that case, promoter, I don't know whether regulation 10 would trigger or not, because there are two different provisions. One is relating to succession, where irrespective of the persons who is getting shares in succession is exempt from takeover open offer obligation.
Okay.
Voting will be done by the trustee in all such cases, whether professional trustee or a family-based trustee, strictly in accordance with the trust deed. If the trust deed tells the manner in which voting has to be undertaken, if a prior authorization from the board of trustee or any other person has to be taken, if it is written in the trust deed, it has to be followed.
Okay.
Yeah, so here the only question was whether regulation 11 would require exemption is required or not. I believe there will be no requirement of exemption, because there is a specific exemption.
Automatic.
Succession can happen to any third party also.
It's a test in case of a testamentary trust.
Yes.
Okay. How can subsequent voting right in a matter of listed company be handled when professional trustee are managing the trust affair?
That will be totally as per the trust deed. If the trust deed is giving unfettered right to the trustee, then he or she may exercise the right accordingly. But otherwise, obviously, as per the deal will.
Okay. How can succession planning be structured to mitigate the potential impact of estate duty if it is reintroduced in India? For example, in case where the settlor reside in a house settled in the trust to retain possession of the keys to a locker containing valuables. Now, Manoj, this question, when you give answer, people are every year when the budget comes, people thinks estate duty will come,
estate duty would come,
and
yes.
then everybody rush for discussion about the trust formation. So please explain this.
So once assets are transferred to irrevocable trust, it becomes a separate entity. It is not the settlor who is owning those assets. It will be owned and controlled by the trustee for the benefit of the beneficiaries. So in such cases, obviously, further transfer is not required in case of death of the settlor. So ultimately, so there will be no transfer from settlor to his successors, and hence there is no question of inheritance tax there. So obviously, if you are transferring the assets into a family trust, and of course this demise, the trust continues to own the shares or assets of the family, there will be no inheritance tax, as the normal planning happens in many of the jurisdictions where there are this kind of inheritance tax law.
Okay. Can we have a copy of all presentation made in this webinar? Yes, we will send it to you, Mr. Sandeep. TDS is deducted on the income earned by revocable trust, and TDS certificate is issued in favor of revocable trust. However, income has to be clubbed in the income of settlor. How to claim TDS in ITR of settlor?
In case of revocable trust, you are talking, yes, if it is a revocable trust, yes, all the tax liability is of the settlor. So he has to assess his tax liability in consolidating the assets held in the trust or income arising from that trust, and obviously to pay tax. So they can take the benefit of the, obviously, I don't remember the form through which this TDS would be transferred, but they can claim fully.
Okay. Ravi, Mr. A is a settlor and the beneficiary are children, and B, husband of the Mrs. A, is Mr. Okay, is Mr. B being spouse of settlor make it a revocable trust merely due to spouse being the beneficiary?
No, it does not. Revocable has to be mentioned that it is revocable, and revocation can be done by the settlor herself, not by somebody claiming to be spouse of the settlor.
Okay, transfer of property would be tax free for a irrevocable trust, but stamp duty would still be applicable, Manoj?
Yes.
Yes. Other than in case of transfer through will.
Will.
How is trust more beneficially than will?
You need not to go through the ruinous process of probate and proving a will. So I think that is the biggest benefit
That
you
is the
get in
biggest
takeover.
benefit. Yes.
Okay. What if it is indeed to have professional person to manage trust holding listed company shares settled by promoters in trust, Manoj?
So they are not allowing it. There will be no exemptions. It would trigger open offer obligation.
And SEBI is planning to change this law or not?
I don't think they will allow.
What is the reason?
They don't want to shift the control of listed company share in the hands of some professional or independent person other than the family members without takeover open offer obligation.
Okay. But SEBI was discussing about earlier also that they may shift this, but they have not done.
They have not. They are not. They are not. They are very much clear that.
Yeah, Ravi.
They can very well do. They have got all ecosystem. Debenture trustees are there. Maybe
Yeah.
define who could be the
Still that the control, because the trustees are the person who is controlling the assets in the
Right.
day-to-day affairs. So voting right is the trigger point for takeover of open obligation.
Well,
So voting
trustees
goes
are
to the
all-
trustee. They don't want that to happen.
Okay. What if it is indeed intended to have professional person to manage trust holding listed company shares settled by promoter net trust not allowed? Okay.
They can be, this can be, but there will be takeover open offer obligation. If they are willing to give open offer obligation, they can shift it.
Please clarify and transfer of private company shares to trust on who will control the companies and tax liability of transfer of shares to the trust.
Obviously, sir, transfer of any assets, other including private company share, would be exempt if the beneficiaries are the family members or immediate relatives, where the transfer is exempt under section 56(2)(10). Otherwise, it will be taxable. And post that, the control will remain with the trustee, who can be independent person, a part of the, who can be settlor or family member, anyone. So those person would be controlling and giving taking decision on the voting rights as per the trust deed.
Can trustee contribute to the corpus of the will or of the corpus of the trust? Can trustee contribute to the corpus of the trust?
So by definition, trustee is only to manage the to take the obligation to manage the assets of the trust and distribute as per the will of the settlor. So trustee is not putting the money, but yes, trustee and settlor can be the same person. In such cases, he may be putting the money.
Okay.
As soon as person puts the money or asset into this, he becomes the settlor, not the trustee.
Okay. What are the regulatory implications involved in the creation of trust, Ravi? Though you have explained, but this.
You'll have to see a lot of laws depending on the nature of entity in which one is conducting the business, nature of business itself, and the nature of assets he wants to bequeath to the trust. So all these, I mean, I told about sectoral laws may become applicable. Sir has given entire presentation on how SAST becomes applicable in case of listed entities. Company law, of course, if the company, in case of you want to do succession planning for companies or group of companies, then company law will become applicable. FEMA, if your beneficiaries are outside and trust is in India, then FEMA also. So it's a very dynamic field. I mean, succession planning can be done. And good thing is, if you see it from another perspective, good thing is that regardless of the dynamic realm, the trust and succession planning through trust can cater to each of these.
Okay. Okay. Is there any minimum net worth threshold for determining whether establishing a trust is necessary?
No,
There is
sir.
no such prescription yet.
How can succession planning be structured to mitigate the potential impact of estate duty if it is reintroduced? Okay, this is
Yeah.
again question has come. It is compulsory for promoter to take prior permission of the SEBI if the beneficiary are also existing promoter of the listed company, Manoj?
Yes, yes. As I've
Can-
discussed, we have to make an application to say.
Okay. Can corporate trust and they give exemption also?
Yes, yes, they are giving tips.
Okay. Can corporate trustee also transfer asset to the trust?
Corporate trustee.
Huh? But how the corporate trustee concept has come?
There is no concept of corporate trustee.
Okay.
SEBI is not allowing professional trustee. If they are saying some company, private company or LLP can create
Mr.
it.
Agarwal, Mr. K.K. Agarwal ji, if you are meaning corporate trustee, mean professional trustee, also transfer asset to trust, that is separate, but there is no concept of corporate trustee word. Can we consider family agreement succession? What is the legal status of the same?
One way to achieve succession, but usually that path is a very treacherous path. It requires a lot of conflict resolution, and ultimately it's another route. It's a different route to arrive at succession planning.
One,
But consider it that this is going to an MD. Trust route is like going to an MD and doing succession planning through non-invasive routes. Family settlement presupposes existence of a dispute and conflict. So it's more in the nature of a compromise, and it's like a surgery.
okay. One person created a trust with 5 family members or 4 others as trustee and developed a museum. After his death, can the family trustee liquidate the trust and sale of the museum item?
Museum.
Huh. One person created a trust with 5 family members and 4 others as trustee and developed a museum.
Is that a public property now?
Public property.
Museum?
Is it a public property? If it is a public property, obviously the
Then no.
situation becomes a totally different because
But museum means that he has created a museum, maybe doll museum, maybe something individual museum.
So if it is a normal asset or business, any commercial entity, yes, it can be, yes.
Okay. Whether private limited company is better than trust for succession planning?
Ultimately, in case of private company, there will be shares and then shares will be owned by someone. So the situation will remain the same. Here we are talking about putting all the shares into one entity, which is a trust for succession, not in the individual name who can dispose it off.
Okay. Can there be
I
more
think question is because the company law does not allow automatic or easy transfer of shares of a private company because it requires prior approval of the board of directors and restriction through the articles of association. Yes, that restriction can be there.
Then the gentleman should be informed that by a special resolution, the color of the company can be changed.
Yes.
It can become a
So
public
it
company.
depends how much percentage the person is holding
Yes.
in the trust, in the private company.
Okay. Can there be more than one settlor in the trust?
Yes.
Yes,
Okay.
there can.
Our client are interested in creating trust for their family business running in proprietary partnership with family members and private company with only family members. Which will be the best model for creating trust?
We'll have to understand the objectives in detail.
Yes.
But
In detail,
I think
Mr. Prashad, you can discuss with Ravi and explain to your point. He will give you answer for this. Mrs. A is a settler. Mrs. A is settler and beneficiary are children. And B, this question we have already done. This we have done. She has asked again. Does SEBI allow trust to have corporate trust? Again,
no corporate trustee, only individuals who are part of the promoter group.
okay. Can I bequeath my interest in a specific trust to my lineal descendant in my will?
Yes.
Okay. If the
If
trust,
if the assets are already transferred to the trust, then you don't have any right unless it is a revocable trust.
Correct.
okay, if a trust settled in 2025 with shares of private unlisted company shares and 2027 the company shares are listed, then takeover code will apply.
Yes, but at the time of approval of DRHP, clearance of DRHP, they will ask for reconstitution of trust deed in case it allows third party to be beneficiaries or third party to be a
Right.
trustee of the trust. In
Okay.
such case, they would ask you to modify the trust deed.
Okay. Does the spouse of the settlor also being a beneficiary make it irrevocable trust?
Irrevocable, revocable, it has nothing to do with the family member or who is the beneficiary or settlor. It is totally in the structure of the trust, which is
It has to be the nature of the trust.
trust.
Okay. Do we have any precedent of listed company shares has been bequeathed by the promoter to a testamentary trust?
There will be certain cases, yes. But offhand, I cannot say that this is through will or testamentary trust.
Okay. Whether trustee can be family member who are also beneficiary or must be outsider?
No, it has to be family members in case of listed company. Unlisted company, there is no restriction. Other assets, no restriction. You can put.
So you mean to say, if there is a listed company, if you have you can make a trust with outsider.
Yes.
But if you are making a listed company trust, then outsider will not be allowed.
Yes.
For
If the
exemption.
beneficiaries are outsider, then no tax exemption. It will be taxable event. Transfer of asset to the trust.
There's also a recent judgment from ITT, but I discussed it with Manoj sir. He told me the law is old. They're just
Well settled position.
reaffirmed the law. Yeah.
No exemption. No
No
exemption
exemption to
for
outside.
anyone. Yes.
Okay. So we have completed all the questions and time is also over. So thank you very much, Manoj, giving various aspects of tax listed companies' point of view, and Ravi to tell us the entire journey of the trust route. What are the advantages, how it has been done, that is there. Manoj, the last question has come. Do we have any president of listed company shares has been bequeathed to the promoter or to the testamentary trust, whether Rakesh Jhunjhunwala was same?
I have not gone through this case study of Rakesh Jhunjhunwala in any of his case, whether it was through will. So I can't comment upon that.
Okay. So thank you, Ravi. Thank you giving the complete journey of this, and Manoj for giving the detailed analysis of tax aspects. Thanks all participants, those who have come in a big number. This is a very technical subject. Until last moment, the majority people are still there. And we have tried to give answer of all 40-45 questions to them. In case any question is unanswered or you think our question has created some new confusion, please provide us, and for all the benefit of everybody, we will send the presentation to all. Okay. This will be thanks for cooperation in the presentation team for such a nice picture and detailed note on the subject. Thank you very much, Ramesh. Naveen Kumar, thanks a lot for insight session. Thank you very much. Friends, thank you all. Thank you all participants. Now, before say goodbye for today's program, I just want to inform all our knowledge journey is continue and it will be continuing without any break. 4 to 6 Friday. That is our brand of corporate professional, and we want to create this and we want to continue this particular legacy. So our legacy is without any succession trust. So the succession trust is here, that every partners, every team member of the CP who are the part of this webinar series, they are committed, and this succession planning will continue on this. We have created this as a legacy of CP, and we want to do it. We want to share more and more topic, more and more things. Mala sir, we will share the presentation copy to you. As I told you in the beginning, our next knowledge sharing session is on 17th January. That is leaning out of group consolidation and simplification of group structure. As you are aware, we formed companies, multiple companies. Earlier there was a license laws, then there was a land acquisition rules. So we people have formed multiple companies. You require some license, you require some business, you form the company. After the work is over, then these company are in the group and creates liability on you. And number is also unnecessary, creating the burden on compliances, burden on non-compliance issue, because you sometimes miss out this also. So the best way is that you must restructure all these multiple companies in the group. So there's a leaning out concept that whatever relevant is, you do it, whatever relevant, you just consolidate. We will discuss threadware, but what are the issues, how these types of company has created, and what are the disadvantages to the companies if you have a multiple company without any work, or some work you are doing here, some work you are doing there, same type of things you are doing. So what you can do, how you can restructure, what are the cost and benefit, what are the immediately outflow, and what is the long-term benefit. All these things we'll discuss in the next webinar. Till then, thank you very much.